Good afternoon and welcome to today's session on property matters, brought to you by Ascent Reality and supported by Ascent Radio. My name again today is Destiny Unuati Ijibo. So today we are going to be looking at another important topic when it comes to land transaction, and we will be discussing contract of sale. Last week we talked about the other week we talked about defenses to breach of contract. When someone brings an action against you that you have breached the contract, what defenses are available to you. So today we are going to be looking at another very important topic, which is tips to preparing a valid contract of sale. So this contract of sale, we are going to be looking at what are those things that you need to consider before you can say you have a valid contract of sale. That's what we are going to be looking at today. First of all, let's quickly look at contract. What is contract of sale? Now, contract of sale refers to an agreement between two persons where party A agrees to sell and party B agrees to take that property. Simply put, it's a situation where the property owner is desirous of transferring title to a purchaser, and the purchaser parts with some money. Now, what the property owner is giving out is his property, while the purchaser is giving out his money. So they are exchanging property for money. That is all about contract of sale. It therefore means there must be a transfer of interest in a property, and there must be a transfer of money from one hand to another for there to be a contract of sale. Now, many persons have had situations where the contract they have entered after going through the rigors of drafting, doing searches, and all of that. They have ascertained persons who are interested in the property, but in the end, they end up having their contract held to be invalid because certain things were not put into consideration at the time of preparing such contract. So we are going to be looking at some of those things that you must consider while preparing your contract of sale. They are elementary, however, without these things being present, your contract will be rendered invalid. When one is missing, the entire contract will be deemed to be invalid. So we are going to be looking at some of those things and how you can make it work without falling short of the requirements of the law. Now, the first thing when it comes to contracts is an offer. When it comes to contract of sale of land, there must be a valid offer. Now, an offer is that stage of the contract where a person offers to buy or to sell a particular property. Now, the situation here is it is either the property owner is offering to sell his property to a purchaser, or the purchaser is offering to buy the property from the property owner. It doesn't matter who is making the offer. What is important here is that an offer must have been made. Now, the person making the offer is known as the offeror, while the person who is going to accept the offer is known as, or the person who the offer is being made to is known as the offeree. Now, for there to be a valid offer, there are some important elements that should also be there. When you are making this offer, you must state the property you want to sell, and some of the things that you also need to consider is the size of the property and how much you intend to sell the property. That is for the vendor. Now, if it happens that it is a purchaser that is making the offer, he must state that he must address it to the property owner that, okay, Mr. Adam, I want to purchase your property located at so place, and I will want to get some other information necessary for me to acquire this property. So you must state the exact location of the property and perfect description of the property. Is it a 2 plots of land? Is it 5 acres? You must be able to state what the property looks like in the offer letter. Without you having any of these things contained in the offer letter will be deemed to be invalid, because It can be that you are just writing a formal letter to someone else about some other subjects. But if you put all of this information in the offer letter, then it can be held to be a valid offer. Now, on the other hand, you also need to look at the fact that there must be an acceptance of that offer. So another element that you need to consider when you are preparing a contract of sale, there must be an acceptance. Now, what is acceptance? Acceptance is refers to that fact where the person whom an offer has been made to accept or agrees to the terms that are stated in the offer letter that has been sent to him. Let's say, for instance, Mr. Adam wants to sell his property to Mrs. Eve. Now, he has sent a letter to Mrs. Eve that, okay, this is my property, this is what is required for you to purchase this property. Then, Mrs. Eve must state clearly in her letter in reply to that offer letter, okay, Mr. Adam, I have accepted to purchase this, your property, according to the terms you have stated. Or you can also decide to make a counter offer. Let's say the vendor stated that, okay, I'm going to sell this property to the tune of, okay, let's say 5 million, and you as a purchaser, you are saying, no, I don't want to pay such huge amount. I'm going to pay 2.5 million. So you can make that counter offer. So whatever the case may be, there must be an acceptance. After you have had all of these discussions, you will now state clearly that, okay, I have accepted to purchase this property and so amount. Also, if you are the one as a purchaser, you are the one who made the offer, the vendor must as well state that, okay, I have accepted to sell my property at this rate according to the terms and conditions which we have agreed to in the offer letter. So all of these things must be contained in the acceptance. So acceptance is a stage where the person who is accepting the offer that has been made agrees to sell or agrees to buy that property. Now, the words that are usually used is that, okay, the purchaser agrees to take that property subject to the terms and conditions stated in this contract of sale. Then for an offer, then the vendor usually states that the vendor is desirous of transferring his title to the purchaser subject to the terms and conditions contained in the contract of sale. So those words must be contained in every contract. Like I said earlier, you must state that the vendor has the desire to sell that property. Then the purchaser also has agreed to purchase the property. Those two keywords must be contained in every contract or sale for it to be valid. Now, there must be an intention to create legal relation between parties. You have started exchanging letters during the offer stage, and you are now, there must be stated clearly that, okay, there is need for us to have a binding relationship, a binding agreement between parties. There are some situations where persons just discuss about property matters. Let's say Mr. Adam is a friend to Mrs. Eve. They are just discussing, okay, I have a property at so place, and Mrs. Eve decides to ask, okay, how are you going to sell the property? What's the value of the property? And all of that. That is main discussion. So they must be, the parties to contract of sale must be intentional that, okay, I want to sell a so amount, and the other person must state categorically that I want to also purchase this property. So that intention must be clearly seen by both parties. Sometimes it will not be clearly written down, but it can be inferred from their relationship. So you must ensure that it is clearly stated that you parties to the transaction intends to create a binding legal relation between them. Then another important thing that must be considered when you are preparing a contract of sale is the consideration. Now, consideration refers to the sum that is to be paid for the purchaser to acquire that property. Now, if Mrs. Eve, the names we are using for the purpose of this discourse, Mrs. Eve has decided to purchase a particular property, the amount that property is to be bought for must be clearly stated in the contract of sale. It is not enough that you state, I have decided to purchase the property as a purchaser and the vendor has agreed to sell. That will not be sufficient. You must be able to state, this is the amount for which I am purchasing the property. You must state there that you have transferred such amount, or you have paid a certain amount of money to the vendor, and the vendor must acknowledge it, that okay, I have received so amount, and upon receipt of this money I have transferred property located at so place with size, I have transferred it to the purchaser. So you must ensure that the amount for which the property is purchased is clearly stated. If the amount is not stated, that means that contract is invalid. There is nothing you can do about it. It cannot be enforced anywhere because the purchase sum was not paid, and it is not reflected in anywhere that the purchase sum has been paid. So consideration is a vital element which must be found in every contract for it to be valid. Another thing you also want to look at when you desire to have a valid contract of sale is competence and capacity. What do we mean when we are talking about capacity? It means the person who is selling or the person who is buying must have the required legal authority or backing to sell or transact when it comes to that property. Let's say, for instance, a person who is a minor, that is, a person is not up to 18 or 20, depending on the jurisdiction of the person who is buying and selling. Now, if the purchaser is not up to age of maturity, it therefore means he does not have the capacity to enter into that contract. Other lack of capacity could be that the person is of unsound mind. Now, if it's the person that doesn't have that mental capacity to enter into any contract, or maybe the person cannot engage in any meaningful discussion, such person is incapable of entering a contract of sale. So you must ensure that the person you are entering into a contract with has that requisite capacity. If, for instance, a person approaches you that, okay, Mr. Adam, I want to buy your property, you should be able to ascertain whether the person is in his right frame of mind to purchase the property. Is the person in good health when it comes to his mental aspect? Then another thing you may also want to consider is there are some persons who have a lucid period. That is, they have mental challenge, but sometimes they are always in good mental state. At other times, it may be in other side. So if it happens that at the point of entering the contract, the person is in his lucid period, then the contract can be held to be valid. But if it happens that, let's say, between the hours of 12 and 4, this person is usually have mental challenge, any contract that the person enters between that period, between the hours of 12 and 4 p.m., such contract can be held to be invalid because the person is not within his lucid period. And also, if it happens that the person usually have his lucid period between 10 a.m. and 4 p.m., that's when usually okay, the person can validly enter the contract or sale. Another thing you can also consider when it comes to capacity is a person the sole owner of the property. If the person is not the sole owner, it means the person must obtain the consent of other co-owners before he can sell that property. So if he's selling as the sole owner, whereas there are other persons who are interested in property, that means the person does not have the requisite capacity when he has not obtained consent from other persons who have interest in the property. So you must ensure when you are entering a contract or say you do your due diligence to know whether the person who you are transacting with has the capacity to sell that property. Another thing you also need to look at is mutuality of obligation. Mutuality of obligation. It means each party must have a role to play in the contract of sale. Let's say you are entering a contract and all of the terms and conditions, the covenants contained in the contract are to be performed by just one party. That contract will be held to be invalid. There must be something that is required of the purchaser to do, and there must be something that the vendor is required to do under that contract. Now, if there is no mutual responsibility under the contract, it can be held to be invalid. So you must ensure that, okay, these are the things that are expected of the vendor under this contract, and these are the things that are expected of the purchaser under the contract. Now, if those terms are performed, then the contract remains valid. But if they are spelled out, the person who the particular covenant has been expected to perform or obey, the person fails, then you can bring an action against that person to perform that particular act. But if nothing is stated, let's say you are entering a contract, the vendor has no obligation at all, just the purchaser, pay the money and go. No, that contract will be held to be invalid. Now, on the other hand, if the purchaser has no obligation under the contract, therefore, it can also be held to be invalid. So there must be mutuality of obligation. Party A has a role to play, Party B has a role to play for there to be a valid contract. Another thing we also want to quickly put in here is there must be commencement dates. Now, for a contract to be valid, you need to insert that commencement. You need to ensure that there is a certain date that is known to both parties to the contract. Okay, the contract is going to commence or take effect from the 14th of April 2022. Or we are processing title to the property. Once the title is processed, then Party B can take the property immediately. And you must show that, okay, this is what is happening at the moment. That, okay, once this thing takes place, the purchaser will take over the property immediately. Now, if there is no event that is certain to take place for the purchaser to take the property, and there is no specified date in the contract of sale, therefore that contract can be held to be invalid. So you must ensure that there is a known date for the contract to commence. Then another thing you also want to look at is to ensure that there is an event. In case there is no certain date, there is an event that may take place for the contract to take effect. The one last thing you may also want to look at, though it's not exhaustive, is execution. So parties to the contract has to append their signature. They must sign. It's not enough for you to have your names on the document. If the contract is not signed, any of the parties can say, I never signed this agreement, therefore it's not binding on me. And if it's not binding, that means it's not valid when it comes to that person that you are bringing that contract to. So you must ensure that when you are entering a contract, every party to the contract signs. If there are 20 persons who have their names on the document, each of those persons must sign that document for it to be binding on that person. If the purchaser signs and the vendor does not sign, it is not binding on the vendor. And if it's just the vendor that signed and the purchaser did not sign, therefore it's still not binding on the purchaser. So you must ensure that every party to the contract signs that contract of sale. Now, in brief summary, when it comes to contract of sale that you want to have a valid contract of sale, you must ensure that you make a good offer, a valid offer that contains the terms and conditions which you want to sell or buy that property, which is the subject matter of the discussion you're having with the other party who is a member of maybe the person that wants to sell. Then another thing you also need to look at is to ensure that it is clearly stated or it is clearly shown that you intend to have a binding legal relationship between the two parties entering into the contract. Another thing you also need to ensure is that there is valid acceptance. The person must state clearly that I have accepted, I have agreed to purchase the property, I have agreed to sell the property for it to be valid. You also need to ensure that you have a certain date that the property is going to be transferred from the owner of the property and from the owner of the property to the purchaser. If you have all of these things factored in a contract of sale, then you have a valid contract of sale. That's how far we can go today. I hope you have learned one or two things from today's session. And I hope to see you next time. Follow us on all our social media platforms where you'll continue to get more of these